and we'll go ahead and start this. So, Attorney Davis, I'll turn this over to you. Good morning.
All right. Well, let me situate getting my screen shared. I think I'm sending a request over. Get this PowerPoint up and going. All right. Can everyone see the slides? Is that coming up all right?
Yep,
Perfect.
looks
Perfect.
good.
All right. Well, as he mentioned, I'm Davis Martin. Really good to be with you here this morning. Um, I am counsel at Willis Law, so I'm mid management, above, just above associate and just below partner, and hopefully on that partner track. So again, really happy to be with you here today. I've been with Willis Law for about 5 years now, coming up in the next couple of weeks, and we are really trying to be on the forefront of advising our clients, corporate or otherwise, on the kind of emerging topics in the legal world. And this is kind of the next big one. So we've got this Corporate Transparency Act that the Treasury Department and Congress has enacted. A little bit about our firm first. We go by this vision of RISE. So on the outside, we've got results and excellence. We want to be the best firm in Southwest Michigan, in Michigan, overall. We can't get there without having really good results and really good excellence for our clients. But what we really think makes us different is these middle two. So I am third and shoulder. I am third if you have a faith that's first. The person across from you is second, and then you put yourself third in this idea of servant leadership for your clients. We also like this idea of shouldering. We've seen our best work with our clients is when we're able to not only just be transactional, where hey, they come to us, we do the work, and we send them on their way. No, we're walking alongside them, we're shouldering with them through all the different aspects of legal representation that they might need. You guys are business owners, you know that every day looks a little bit different, and sometimes that involves needing legal help. So we want to be there to shoulder with you, not just being, kind of the instructor and sending you on your way. We want to walk through that process with you. We've got approximately 30 employees between our offices. We've been consistently listed as one of the best and brightest companies to work for. We've been rated in Best Lawyers in America, Best Law Firms in America, AV Martindale, Super Lawyers as well. So we are a full service law firm, anywhere from business and corporate law to estate planning, high level net worth clients for estate tax minimization, litigation, business, corporate estate, and otherwise. One of the really key things about our firm is giving back. One of the ways that we give back is our firm, and the proceeds of our firm fully fund the Corporal Christopher Kelly Willis Foundation, which is the brother of Sean and Michael Willis, who started this firm, who passed away. So this helps create 100% scholarships for the children of veterans who have been killed or 100% disabled in combat. So this is a way that anytime I'm billing, I'm knowing, yeah, this is going towards a good cause and supporting, these children that really need it for their parents who are heroes and have sometimes given the ultimate sacrifice for our country. A little bit about me. I am actually from Columbus, Ohio. But before you moan and groan, I'm not a Buckeye, so you don't need to boo me off the. I guess can't say off the stage, but I am again originally from Columbus. Went to Cornerstone University in Grand Rapids and played baseball there. Then went back to Ohio for law school and ended up back here in West Michigan and love it. So economics and business administration is my background. I really like the corporate work. I like numbers sometimes and how they associate with different things here. I practice primarily in corporate representation, general counsel. I do mergers and acquisitions. I do some asset protection and some estate planning, a little bit of real estate and civil litigation to round out my practice. I'm a member of the Grand Rapids Young Professionals Association, uh, County and Kalamazoo County Bar Associations, member of the Cornerstone University Alumni Board as well. So let's start diving into the Corporate Transparency Act. I will note that I think there is a chat function. So at the end, you can either put questions in the chat or I can just open up, the floor here. And if you have questions that you want to speak over, would be happy to do that and have reserved some time to do that. So we'll go over a brief overview of the act. We'll talk about some of these cases that are actually challenging the act itself on whether it's constitutional or unconstitutional. And then we'll go through some top 10 compliance tips and then finish off with what are the next steps for you guys when it comes to your business. So what exactly is the Corporate Transparency Act? This was enacted in early 2021 as part of the National Defense Authorization Act. The idea, the goal behind this is to combat financial crimes, specifically money laundering regimes. So what it does is it really focuses on small businesses that have the potential to be shell companies. And then if we've got a small business, we're looking at the small business that is owned by that small business and so on. So there's this parent subsidiary relationship that this act is really trying to kind of uncover who is the actual beneficial owner of these different entities. So what it does is it essentially establishes these reporting requirements for any quote unquote, which we'll define reporting company. So is the Corporate Transparency Act actually constitutional? The U.S. And the National Small Business Association, which is an organization, they filed an action in federal court in Alabama, and it essentially alleges that the act is invasive. It constitutes an unlawful search and seizure of your personal information, which we'll get to as to what you have to disclose. And it essentially alleges that the act is not within the bounds of Congress's authority. If I go back to history in high school, I know that Congress only has the power to act if within those enumerated powers in the Constitution. Well, the National Small Business Association basically raised their hand and said, well, this isn't within that. This is outside of those bounds. So that's the basis of their claim. Then they essentially allege that the act is vague and calls for criminal penalties for this. That takes me back to constitutional law in law school, where if a provision, a legislation is vague and can't be appropriately applied, that is a basis for being unconstitutional. So the U.S. District Court for the Northern District of Alabama actually ruled in favor of the National Small Business Association and said it was unconstitutional. The Treasury Department has appealed this ruling. There was oral argument in the appellate court on September 27th, 2024, still awaiting a formal ruling on that front. So what does that actually mean? Again, that's a federal district court in Alabama. What does that mean for us in Michigan or Colorado, California, etc.? At this time, that federal court's ruling only applies to current members of the National Small Business Association. So if you're not within that, I think it's a 60,000 members in that NSBA, this act still applies to you and you still have these reporting requirements. Any that's not a member still must file a report, and we'll go over some of those deadlines later here. Should also note here that the Small Business Association of Michigan has filed an action alleging that the act is, again, invasive and unconstitutional. There's other states like Maine and Texas that are also following suit with this, still waiting on the court to actually make decisions for those additional states there. So let's start going through these top 10 tips, as I've called them. Goal here is to kind of be at a 10,000-foot view of the different compliance tips for the Corporate Transparency Act. And then if there are additional questions, again, we can address those at the end of the session here today. Or if you need a follow-up call or meeting, we'd be happy to set that up as well. So again, what is a reporting company? This is going to be a very lawyer definition, but it's most corporations, limited liability companies, and other entities created to do business in the United States that are not an exempt company. And we'll go over the definition of that. So this also includes entities that maybe are formed in Spain or England or Germany, wherever, but have filed to do business in the United States. Essentially, the Treasury Department wants a full scope of every business that's not exempt. They want to know who was the beneficial owner of that, again, to try to combat money laundering schemes and other financial crimes. Tip number two, is my company exempt? So there are numerous exemptions, 23 to be specific, from kind of the expansive definition of reporting company. So we've got basically a general funnel. Everything is a reporting company. Now we've got these exemptions to kind of carve out specifics. Publicly traded companies, nonprofits, large operating companies are some examples. A large operating company has, over 20 employees and over $5,000 in gross revenue in the prior year. We can send out a list. This is a link as well once we get the slides to you on all the different ones. There's a common trend in the different exemptions. So again, a publicly traded company, they have to disclose things to their public with annual reports. Other things are investment companies, banks. Lots of those are already regulated by the SEC, where a lot of this information is already disclosed there. So that's kind of the common theme is, well, if we've already doing compliance for information on beneficial ownership with these other government agencies, these are going to be some exemptions. The one that we see most often, again, is this large operating company for our clientele. Where they've got a very large business, over 20 employees, over $5 million of gross revenue, so we can try to avoid having to file for that purpose. This is again tip three. What is a large operating company? Just kind of went over that. So again, more than 20 full-time employees, an operating presence in the United States, as well as a federal income tax return in excess of 5 million of gross receipts or sales. That'll get you to be the definition of a large operating company, which again would make you exempt for reporting purposes. This is also really important because another exemption is being the subsidiary of an exempt company. So if this top company is a large operating company, any company that is below that as a subsidiary is now also exempt. What type of reporting information? This is tip number 4 here. So if your entity is not exempt, you're going to be required to report the following information regarding your entity: the full legal name of the company, as well as any trade names and doing business as names, the AKA, assumed names that you have to do with Laura here in Michigan. You got to do the business street address, the state of formation, as well as the EIN or the TIN that you got from the IRS. For owners, reporting companies must also report information regarding who the beneficial owners are and who the company applicants are for that reporting company. So if you are, one, a beneficial owner, or two, a company applicant, again, we'll continue to define those, you need to provide the full name, date of birth, address, and an unexpired driver's license number or passport number. They actually make you scan in and file a scanned copy of, we typically do driver's license. We've done passport 1 or 2 times here, but so you have to scan that in with that beneficial ownership information report when you send it into FinCEN. So who qualifies then? This is tip number 6 as a beneficial owner. So again, that's that first one. So a beneficial owner includes any individual who directly or indirectly exercises substantial control over a reporting company. That essentially is the person who has the decision-making power, or the different set of people who have the decision-making power via a board of directors, primary shareholders, etc. Or option 2, owns or controls at least 25% of the ownership interest of a reporting company. So again, this is a little bit of that argument that these different states have been, or these different business associations have been making, is this is really, really vague. How do you define someone having substantial control? There's no case law on it. There's no facts or circumstances that a judge has said, yeah, this is substantial control and this isn't substantial control. We don't have that line. So again, that's one of those areas that they're looking to challenge based on that. What is substantial control? When does an owner actually have substantial control? It's a really, really great question. The best kind of lawyer answer is we got to wait and see to see what a judge interprets that as we get some case law. Right now, again, our interpretation and the general interpretation is, yeah, it's got to be a board of directors, a manager of a manager managed LLC, etc., for that purpose. Continuation of tip number 6, again, who qualifies as a beneficial owner? The easy example is the client who just has one business, might be owned by a couple different people. That's really easy. So let's take company A, for example. So company A is owned by owner 1 and owner 2 in equal 50% portions. Each of them are beneficial owners as they exceed that 25% threshold. So again, that's the easy example. Where it gets more complicated is when we have clients who have many companies, 20, 30, 40, 50 companies sometimes, and they all kind of interrelate. We've put together these organizational charts for our clients where, it's kind of a family tree, and you start to have a ton of different branches to these different parents and subsidiaries. So it can get a little bit more complicated once we start looking at this next kind of more complex example. So hopefully this I can track this well enough to explain it well. So let's say we've got company B. So instead of company B being owned by individuals, it's actually owned by two companies. So company B is owned by company C and company D in equal 50% portions. But company C is now owned by individuals Y and X, or excuse me, W and X. W owns 30% of C, X owns 70%. Company D is owned by individual Y and individual Z in 50% portions. So again, walking through and kind of laying this out, who would then qualify as a beneficial owner? So the reporting requirements wouldn't say that company B should list company C and D as the beneficial owners because those are also companies. So what we actually have to do is essentially calculate and impute who is the actual beneficial owner for that 25% threshold. So what we do, let's walk through them. This is W. First, we'll start off with. So again, company B owned by company C in 50% portion, but W owns 30% of company C. So we do 30% of 50%, that's 15%. So W again is not a beneficial owner of company B. The only other option that would make them a beneficial owner is if they did have substantial control over the decision-making power of the company. But for the threshold, 25% threshold purposes, they would be falling below that. Let's take individual X now. They own 70% of of C, which owns 50% of B. Well, 70% of 50% is 35%. So we're above that threshold. So even if they don't make substantial control decisions over company B, they would still be a beneficial owner because they're above that 25% threshold. Y and Z, those are going to be the same calculations here. They own 50% of D, which owns 50% of B. So that's 25%. Again, doesn't matter if they exercise substantial control over B, they're both at or above that 25% threshold. So again, this is something that where an attorney is really helpful in interpreting, laying out your organizational structure, and making sure that we are accurately reporting all of the beneficial owners for each of your entities. Can a beneficial owner be exempt from reporting for this beneficial ownership information reports? The answer to that is yes. So if the beneficial owner is a minor, if they're a nominee, an intermediary, maybe a custodian or an agent, I've also seen a receiver be in that role as well, or individuals whose only interest in a company is a future interest through an inheritance. Just because someone's named as a beneficiary on a trust that has LLC or corporate interests in it, that doesn't make them a beneficial owner. Creditor is also another way that is again an exemption for a beneficial owner from reporting. Tip number 8, I mentioned we've got beneficial owners. So again, if you're not exempt, you have to file for beneficial owners, the information, as well as what's called a company applicant. So this requires disclosure of information regarding that company applicant. So what that means, the company applicant is essentially the person who actually does the filing with the state. So the articles of organization, oftentimes it's the attorney, so me or a different attorney that is helping file those articles of organization. Sometimes it's myself as well as my paralegal or assistant to get that done. Full legal name, date of birth, address, driver's license number, unexpired, just like with the beneficial ownership. Again, directly files the document that creates the entity and the individual is primarily responsible. So again, let's take, for example, I've got a client who wants to form this business. I am the individual who is primarily responsible for directing or controlling another to file the document. So I'm a company applicant. I direct my assistant to file it with Laura. My assistant is then a company applicant. I should note here that FinCEN has basically limited, thankfully, the entities formed prior to 1/1/2024 do not need to disclose applicants. So if you have an entity that was already formed prior to this year, we only need to file for beneficial owners. We don't need to file for company applicants. If you started 1/1/2024, you need to start disclosing those company applicants. So what are the time constraints? Tip number 9, this is getting to the importance of it. So if you were formed prior to January 1st, 2024 as an entity, that is when I'm saying formation, that's the date that your articles of organization or articles of incorporation were filed with Lara and essentially endorsed. So that's when you receive them back, not on the data file. So if you were prior to that, it's due by January 1st of 2025. So we've got a little bit more time to get that done. But now they've kind of got this phase in this scheduling of when things are going to be due, and the timelines get a lot more restrictive for that purpose. So between January 1st, 2024 and December 31st, 2024, you've got 90 days after formation. But then January 1st, 2025 and on, you're only going to get 30 days after formation. There's also this idea and concept of continuing reporting obligations, which basically says, well, if there's any updates or changes, a new assumed name, a new address, new owners, merger acquisitions that restructure things, we've got 30 days from that date to basically update that beneficial ownership report to make sure that it's up to date for the Treasury Department's purposes. How do we avoid penalties? This is the last tip. So failure to comply with the Corporate Transparency Act can actually result in a fine of $10,000 and/or imprisonment for 2 years. So the way that they do it right now is it's essentially $500 a day up to $10,000. I personally haven't seen any of these actually been doled out. That's not to say that we should sit on our hands and wait on this type of compliance, but we're still kind of waiting to see how much the Treasury Department, how much teeth is actually with this from the Treasury Department. But certainly want to try to avoid all of that as much as we can to make sure we're doing our due diligence. So then finally here, what are kind of the next steps for your business? Certainly would strongly recommend consulting with an attorney to discuss the specific of your entity or maybe your entities and what your reporting obligations are. Again, we walk through all these steps here when we're talking with our clients and new clients on, hey, are we a reporting company? Are we exempt? Who are the company applicants? Who are the beneficial owners? We're walking through that process to make sure that we're fully complying with these requirements. We also recommend reviewing your company agreement, operating or shareholder agreement, and consider adding a provision requiring beneficial members to supply accurate personal information in compliance with the Act. Again, there's this continuing reporting obligation that we need to comply with within 30 days of that change. So we want to make sure we are requiring any beneficial member to essentially cooperate with that requirement from FinCEN. Keep an eye out for a ruling from the 11th Circuit Appeals Court or from Congress. We'll see what Congress is going to do. Again, we've got 4, maybe 5 states that are challenging this act, and it's going to start to continue to pressure Congress into acting, which is always always an uphill climb. But this 11th Circuit Court Appeals Court again heard oral argument at the end of September, so could be in the next couple of weeks, 4 to 6 weeks that we get an opinion on that. Again, at this point in time, that ruling only applies to members of the National Small Business Association. So it's not nationwide, unfortunately. Also, keep an eye out for a ruling from the U.S. District Court for the Western District of Michigan. The Michigan Small Business Association has filed, still waiting for a ruling on that. Keep an eye out for other organizations and associations that file an action. If you're part of one and want to push, your leadership organization to file that, then I would encourage you to do so if you feel led to do so. Watch out for scams. You're going to get mail. I don't remember if you guys recall, but when you first filed your articles of organization or articles of incorporation, you probably got a ton of letters from people who wanted to say, hey, give us $250 and we'll act as your registered agent for a year. Those are essentially almost all scams. So this is the same type of thing. Hey, we'll do it for you. We'll pay, you can pay us X amount of dollars and we'll get it done. Watch out for scams for that. Again, right now, reporting still required, but we'll continue to keep you updated on kind of the emerging constitutionality and these challenges that are happening in the different district courts as it continues to kind of go up the chain. We'll see how far it goes at this point in time. Again, right now it's in the 11th Circuit Appeals Court, and we'll see how far it goes. But again, this is the Corporate Transparency Act is an effort to try to limit money laundering, limit and combat financial crimes. It can seem a little bit of overkill. Once you start diving into the forums that we assist with, all the time, it's not a huge, huge and unduly burdensome type of requirement, but certainly worthwhile to make sure we get done and avoid some of those penalties. So with that, I think that is everything. Let me see if there are any questions. I'm going to stop sharing that. I think there is something in the chat.
Yep, we have one question in the chat and then we can open it up. If people just
Yeah.
raise their hand question, we can.
Sure. Yeah. So the first question says, does it have to meet the dollar amount and employee amount or either? Yeah. So this is a conjunctive type of element. So we've got to meet all of those. So it's got to have an operating presence in the United States. It's got to have over 20 full-time employees, and it has to be at or over the $5 million of gross receipts or sales. So it's got to be all three of them. If you don't hit one of them, then you're again not a large operating company, and you would not be exempt from the act.
I guess I'm gonna ask, I think an easy question or obvious one. So the National Small Business Association members would be exempt. If you're in a pre-2024 and you don't want to do the paperwork, could you join the National Small Business Association and be a member and not have to do this? Is that the easy button?
My understanding is that it is basically frozen. So at the time of filing of that complaint by the NSBA, it was members as of that time.
Okay.
So yeah, unfortunately, it's not as easy of a fix as you think, but it's worthwhile to look into and maybe give them a call. Yeah.
All right. I'm gonna fire one more at you. What about typically as builders or in real estate, we have a variety of LLCs and we're small business owners, so many of them are single member or limited. But I'm going to call them the LLCs that are air quotes around dormant. You have this LLC hanging around that hasn't done anything. Do we need to file for those, or would it be better to clean up and dissolve those?
Yeah, so there is an exempt one of those 23 exemptions that is an inactive entity. And I can throw that specifically in the slides before I circulate them. they've got a kind of a specific definition. But yeah, if we've got something, an LLC that doesn't own any assets, doesn't have anything along those lines, that would probably meet the definition of an inactive entity, so would not require that. And then it's up to you on dissolution. It's really easy to dissolve. There's kind of two ways. This is a little bit of an aside here, but the first way to dissolve is to do a certificate of dissolution with Laura, and then you got to get this tax clearance certificate and go through that process. The easier, more preferable way that we do is we actually amend your articles of organization to give the LLC an expiration date. So we say, hey, we're going to file these articles of organization. We're going to say that the LLC expires on 11/30/2024, and then we can avoid that tax clearance certificate, which typically takes months to actually receive. You have an initial certificate, but you don't get that final one for quite some time. So yeah, just an aside there, but yeah. So again, inactive entity. If we don't have assets in there, certainly if there are still assets in there, I think it's appropriate to file that beneficial ownership report.
Thank you.
Yep.
Anybody got anything else? Feel free to
Yeah, go ahead.
Would you suggest that we go ahead and file before the end of the year, or kind of wait and see what the courts do?
Yeah, I think it's very unlikely that we have, for Michigan specifically, that we have a ruling. Certainly not from Congress. So right now, if the trend stays as it is, even if the Western District Court of Michigan says that it is unconstitutional, it's likely only going to apply to Michigan members of the Michigan Small Business Association. So if you're in that, yeah, I'd say let's wait until mid-December and kind of wait it out to see if the court does make a ruling on that. If you're not, then I think it's probably appropriate to file at this time.
Good question. Oh, here's one.
Yeah, I got another question of where do we file? So this is right on the Treasury Department's website. So if you Google Treasury Department, and then it's specifically the Financial Crimes and Enforcement Network. And I mentioned it a few times. I probably should have noted that, but that's FinCEN. So the acronym for that is FINCEN. So Financial Crimes and Enforcement Network. So if you go on their website, it's basically the headliner there is the BOIR, Beneficial Ownership Information Reporting. It gives you the PDF that you need to fill out, or if you've got all the information ready, they give you a fillable document through their online website to fill that out.
Excellent.
Other thoughts, questions? I am going to put my email into the chat here. That works. So dmartin@willis.law is the best way to get in touch. If you do have follow-up questions, certainly would be happy to set up a phone call, set up a meeting to go over specifics of your company or entities that you have and make sure we're complying on that front. And then sounds like we'll circulate a recording of the presentation as well as the slides to everyone. So certainly, if there are additional follow-up questions, we'd be happy to touch base with you.
Great. Well, Attorney Davis, thank you so much. We appreciate you sharing the information and being available to answer questions to the members. And for those on the call, we will share the recording as well as the slides. Those will come to you via email from the HBA.
Yeah. That sounds
Thank
good.
you.
Hope everyone has a good rest of their week.
Thank
Thanks
you.
for hosting, Aaron.
Thanks, Joe. Appreciate you. Appreciate everybody on the call.